Group 4, I will going to tackle the Title 11, Non-Stock Corporation, Title 12, the Close Corporation, Title 13, Special Corporation. But first, we're going to tackle the Non-Stock Corporation. Definition. Non-Stock Corporation. Based solely in the definition of the non-stock corporation, we should remember two things. One, it may have income, but the income is only incidental. And number two, if ever it has income, it is not distributable as dividends to its members, trustees, or officers. They will not receive anything like dividends. Purposes. Section 88. Purposes of non-stock corporation. Section 87 enumerates the allowable purposes for which as a non-stock corporation may be organized. So, all of these is allowable purposes in which to incorporate a non-stock corporation. It is also can be combined, like if it's religious, then it's also charitable. The non-profit character of non-stock corporation. A non-stock corporation cannot engage in business with the object of making profits. General rule. Non-stock corporation is not allowed to engage in business and not allowed to income directly or indirectly. If ever non-stock corporation have an income, it is called incidental profit. So, what is incidental profit obtained from corporation? Take note the underlined words. A non-stock corporation, as a general rule, is not empowered to engage in business with the object of making income or profits directly or indirectly. However, it is not prohibited to make income or profits as so incident to its operation, but unlike stock corporation, any profit derived from any authorized activity cannot be distributed as dividends to its members. In this sense, incidental profits obtained from its operations shall, whenever necessary or proper, be used for the furtherance of the purpose of purposes for which the corporation was organized. It is in the sense that a non-stock corporation is considered a non-profit corporate. Chapter 1. Member, Section 89. The right to vote. The right to vote of members of any class or classes may be limited, broadened, or even denied in the Articles of Incorporation or the bylaws. Unless so limited, broadened, or denied, each member, regardless of class, shall entitled to one vote according to Section 88. Unless otherwise provided by the Articles of Incorporation or the laws, a member may be voted by proxy in accordance with the provisions of the RCCP according to Section 88. Each member shall be entitled only to one vote per candidate in the election of trustees, unless community voting is authorized in the Articles of Incorporation or the bylaws. He may cast as many votes as there are trustees to be elected, but may not cast more than one for one candidate. Section 90. Non-transferability of membership. Nature of membership rights. In the absence of restriction, it may act arbitrarily and exclude any person as it may see fit, and the courts have no power to interfere. According to opinion of SEC, December 3, 1991. The manner or mode of acquisition of membership. Membership in a non-stock corporation cannot be acquired except in the particular manner or mode of acquiring the same as provided for its valid bylaws. The manner of admitting new members to a non-stock corporation is governed by bylaws and may not, therefore, be uniform in all corporations. So lahi-lahi, iba-iba, depende sa corporation. Once adopted, such mode of admitting new members must be observed until a new procedure is adopted by the corporation through an amendment of the bylaws or SIG opinion on September 26, 1969, according to its opinion of SEC. Approval of admission of new members. Admission of members is one corporate power. Take note the underlined word, expressly granted under Section 35, the RCCP, in the absence of any express provisions in bylaws as to what body the admission of corporate members is lodged. It must logically be in the Board of Trustees, and the approval of the members of the corporation shall be necessary. What are the qualifications for membership? It is a matter of general knowledge that corporation may validly prescribe certain qualifications necessary for membership and the mode of procedure in which membership can be acquired. Power of courts. Courts are without power to strip a member of a non-stock corporation of his membership therein without cause. Otherwise, that would be an unwarranted and undue interference with the well-established right of a corporation to determine its membership. The non-transferability of membership. Membership in a non-stock corporation and all rights arising therefrom, personal and non-transferable unless the articles of incorporations and the bylaws otherwise provide. Section 89. General Rule. Membership in a non-stock corporation has personal elements accompanied by social and other ties. Hence, except where the article of incorporation or bylaws as provide, it cannot be transferred to any other person who wishes to be a member. The Section 91, the termination of membership. Membership shall be terminated only in the manner and for the cause provided in the articles of incorporation or by the bylaws. Termination of membership shall have the effect of extinguishing all rights of member in the corporation or in its property unless otherwise provided in the article of incorporation or the bylaws.
Section 92. Election and term of trustees. The minimum is 15. Although the articles of incorporation or bylaws can provide more than 15. In a regular practice, the composition of Board of Trustees is 15. The term of office every member of Board of Trustees is 3 years. 15 divided by 3 is 5. So there is 5 board member that the term will expire every year. Example, if his term is 2020, 2023 will be his first term. In 2021, 5 members will expire their term. 2022, another 5. 2023, another 5. Every year, there is an election of members of Board of Trustees. So what will happen to this is that there's a term will expire every year, but also there will be 10 left. In 2021, 5 terms will expire, but there's still 10 members left in the Board of Trustees. The Board of Trustees needs to be a member of the corporation. If non-stock, it is called member. If stock corporation, it is called stockholder. That's the difference between stock and non-stock. If stock corporation, there's a profit. The profit will be distributed to dividend, while the non-stock is non-profit. Non-profit, therefore, not commercial its activities. So it is not business. Not commercial, not business enterprise. Members of the board called trustees. If stock, it is called Board of Director. But if non-stock, it is called Board of Trustees. Then the officers of non-stock is called members. Officers of stock will be based of the number of shares. Example, if the share is 1,560,000 shares of stock and he's the only one holding it, then he can become an officer. But in non-stock, directly elected by the members. One member, one vote. But in stock, the basis of election or why he should be elected is based of the number of shares. Section 93. Place of meetings. There are two kinds of meeting, regular and special. If regular, it is fixed in the article of incorporation or bylaws. If the regular meeting is every Monday of the week, without notice of meeting, they are notified already that it was the regular meeting. But if it's special, they are called by the president or majority of the members. Because in special meeting, the agenda is special also. Particular agenda is only to be discussed. But if regular meeting, there is a lot of agenda. Special meeting possible that it needs to be hurry. That's why it is called special. Meeting can be outside where the principal office is located. For example, if the headquarters is in Makati, the member of non-stock corporation, their meeting can be held in Cebu. But in general rule, their meeting should be in the principal office headquarters. If the bylaws will allow, they can do the meeting outside of the principal office, outside of the headquarters corporation located. If non-stock corporation is in CDO, then they will say that the meeting will be held in Iligan. They can do it also. Because the bylaws said that they can do the meeting outside the principal office provided proper notice is sent. That notice is required. In regular meeting, it is not required. In special meeting, there's a notice. Date, time and place of meeting inside a notice within the Philippines only. If they will say that the meeting will be held in New York, it is not allowed. Section 94. Rules of distribution. Dissolution is already ended. End of life of the corporation. If we say the non-stock corporation is 50 years, it needs to be dissolved. So the corporation is already gone. If the corporation is already gone, it is natural that there's assets, properties, cash, or money. The properties and assets need to be distributed. So, where to distribute? To the members. The rule of distribution is liabilities, those are debts. Obligation, like payables, example, taxes. It should be paid and satisfied. First, in distribution, why needs to be distributed? Because there is assets. First, to distribute in assets. Where to apply assets? In liabilities and obligation. Condition requiring to return or transfer. You can transfer by selling or to donate. Transfer and conveyance is the same, but the assets should be identified. For example, this building is owned by Mrs. Paporo. It should be returned because the corporation is already gone. Gratuitous means donate. Onerous means sell. Donate meaning no money involved. Sell means there's money involved. Charitable, religious, benevolent, educational, not held by non-stock to return. Transfer or conveyed to one or more corporation. So the assets now will be transferred. So where it should be transferred? Either corporation, either societies, either organization. So if the non-stock corporation is educational, the transfer should be educational also. The purpose is educational. For example, if you transfer it to Gaisano, it is forbidden. But if you transfer it to FINMA Education Network, it can be because it is educational. The distribution should be based on the articles of incorporation or bylaws. Distributive rights of the members. sharing of distribution, not debts and obligation, not return or transfer or convey, not similar corporation, or done distributed by the members in a way according to the plan of distribution. Section 95, Plan of Distribution of Assets. They were 15 members. How many is the majority vote? It means 8 votes. Distribution plan is the only thing that we will discuss, having voting rights. Written notice is required because the corporation is dissolved. Non-stock corporation will discuss distribution of assets. Before they will distribute, it needs a plan. 15 times 2 equals 30, divided by 3 equals 10 votes of 2/3. So there is proxy or representative of the members of the board. Example, the board member is Pedro. Pedro's agent is Juan. Juan is now to attend the meeting. He has the right to vote in the plan of distribution.
Title number 12. Closed Corporation. Closed corporation, a corporation in which the stock is held in a few hands or in a few families and the stock is not at all or only rarely dealt in buying and selling. Section 96. Definition and applicability of title. Within the meaning of the Corporation Code, it is one whose articles of incorporation provide the following. Number 1. All its issued stocks, exclusive of treasury shares, shall be held of records by not more than a specified number of persons, not exceeding 20. Number 2. All its issued stocks shall be subject to one or more restriction on transfer permitted by the Code. Number 3. Any of the stocks shall not be listed in any stock exchange or offered to the public. All the 3 features must be presented for a corporation to be classified as a closed corporation within the meaning of the Code, where 2/3 of the voting stock or voting rights of a corporation as defined above is owned or controlled by another corporation which does not fall within the definition of a closed corporation. The former shall be deemed not a closed corporation. So too, a narrow distribution of ownership does not by itself make a closed corporation. Corporations which are vested with public interest such as those mentioned are not allowed to be incorporated as a closed corporation. Section 97. Articles of Incorporation. The articles of incorporation of a closed corporation may provide. Number 1. We cannot easily get shares or right in a closed corporation. You need for qualification and restriction on their transfers. Number 2. In a closed corporation, there is a classification of directors into one or more classes. Number 3. Quorum and voting requirements. The article of incorporation of a closed corporation may provide for quorum and voting requirements in meeting of stockholders or directors greater than those provided in the Corporation Code. Management of the corporation by the stockholders, where the article of incorporation provide that the business of the corporation shall be managed by the stockholders themselves rather than the board of directors. Then the stockholders shall be deemed to be the directors with all the liabilities imposed by the code on directors. Section 98. Validity of restriction on transfer of shares. Restrictions on transfer of shares. One of the 3 distinguishing characteristics of a closed corporation is that all of its stock shall be subject to one or more specified restriction permitted by Title 12. Section 98 imposes 2 conditions for the validity of restriction on the right to transfer shares, namely, number 1. Such restriction must appear in the articles of incorporation and in bylaws, as well as the certificate of stocks. Otherwise, they shall not be binding on any purchaser thereof in good faith. And number 2, they shall not be more onerous than granting the existing stockholders or the corporation the option to purchase the share of the transferring stockholders with such reasonable terms, conditions, or period stated therein. Thus, a restriction fixing the purchase price very much below the fair market value of the share may be invalid. Also invalid is a prohibition against transfer of stocks without the prior consent of the board of directors or of the other stockholders.
Good day everyone, I am Eustiquio de Salvo I. The sections that I am going to tackle is the part of the closed corporations, which is the section 98, 99, and 100 of the Revised Corporation Code of the Philippines. Section 98, Effects of Issuance or Transfer of Stock in Breach of Qualifying Condition. In this section, there are 7 provisions. First, if a stock of a closed corporation is issued or transferred to any person who is not eligible to be a holder thereof, any under provision of the Article of Incorporation, and if the certificate of such stock conspicuously shows the qualifications of a person entitled to be a holder of a record thereof, such person is conclusively presumed to have noticed of the fact of the ineligibility to be a stockholder. In this provision, if one of the conditions stated in the Articles of Incorporation that the stockholder must be a relative only, then if the new person who bought the stock is not a relative, then the transfer of that stock to the person is a breach on qualifying condition. Even if that person says that he didn't know such rule, still there is a conclusively presumption that the new person is aware of such fact. In this provision is that if the article of a closed corporation state that the number of stockholder is only 20, then the new person who bought the stock will be going to be the 21st member of the closed corporation, then it is a breach on the qualifying condition. Even if that new person says that he didn't know such rule, still there is a conclusively presumption that the new person is aware of such fact. Third, if a stock certificate of a closed corporation conspicuously shows restriction on transfer of corporation stock and the transferee acquired the stock in violation of such restriction, the transferee is conclusively presumed to have notice of the fact that the stock was acquired in a violation of the restriction. In this provision is that if the articles of a closed corporation stated that they restrict to sell that specific stock, then the new person bought that specific stock, then it is a breach of the qualifying condition of the closed corporation. Then, even if that new person says that he didn't know such rule, still there is a conclusively presumption that you are aware of that fact. Fourth, whenever a person to whom stock of a closed corporation has been issued or transferred has or is conclusively presumed under this section to have noticed of, first, the person's ineligibility to be a stockholder of a corporation, second, that the transfer of stock would cause the stock of the corporation to be held by more than the number of persons permitted under the Articles of Incorporation, or third, that the transfer violates the restriction on a transfer of stock, the corporation may, at its option, refuse to register the transfer in the name of the transferee. In this provision, the closed corporation has its right to not honor and to not register the transfer of stock certificate to the new person if it breaches the qualifying condition of the closed corporation as stated previously in the provision 1, 2, and 3. Fifth, the provisions of subsection stated in B shall not be applicable if the transfer of stock through the contrary to subsection stated in A, B, or C has been consented by all the stockholder of the closed corporation, or if the closed corporation has amended its article of incorporation in accordance with this title. In this provision, the transfer of certificate of stock to the new person will be valid even if it breaches the qualifying condition of their articles of incorporation, if all the stockholder will agree to amend its article of incorporation, or all of them will consent or allow the transfer. Sixth, the term transfer, as used in this section, is not limited to a transfer of value. In this provision, the term transfer is not limited to a transfer of value only, but it can also be a term for donation. Last, the provision of this section shall not impair any right which the transferee may have, or either rescind the transfer or recover the stock under the express or implied warranty. In this provision, if the new person who bought the stock could not transfer the certificate of stock into his name, then he can claim an applicable warranty, or he can cancel the transaction to the stockholder seller. Section 99. Agreements by stockholder. First, agreements duly signed and executed by and among all stockholders before the formation and organization of a closed corporation shall survive the incorporation and shall continue to be valid and binding between such stockholders, if such be their intent, to the extent that such agreements are consistent with the articles of incorporation, irrespective of where the provisions of such agreements are contained, except those required by this title to be embodied in the said article of incorporation. This means if a stockholder entered an agreement before the corporation was formed, then that agreement will continue to be valid and binding if they intended to be valid and binding after the corporation came to its existence. Second, a written agreement signed by two or more stockholders may provide that in exercising any voting rights, the share held by them shall be voted as provided or as agreed, or in accordance with the procedure agreed upon by them. This means that the stockholders may agree on the manner or system of voting. Third, no provision in a written agreement signed by the stockholders relating to any phase of corporate affairs shall be invalidated between the parties on the ground that its effect is to make them partners among themselves. This means if there is a contract between any stockholders that has an act that making them as a partner to one another, then this will not be invalidated based solely on their grounds, because remember, a closed corporation is an incorporated partnership. They operate as a partnership as among themselves, but the law treats them as a corporation. Fourth, a written agreement among some or all of the stockholders in a closed corporation shall not be invalidated on the ground that it relates to the conduct of the business and affairs of the corporation as it to restrict or interfere with the discretion of power of the board of directors, provided that such agreement shall impose on the stockholders who are parties thereto the liabilities for the managerial acts imposed on directors by this code. This means if a written agreement between stockholder will restrict the power of the board of directors or interfere the powers of the board of directors, then it is not be invalidated. The liability will be for the managerial act. Fifth, stockholders actively engage in the management or operation of the businesses and affairs of a closed corporation shall be held to strict fiduciary duties to each other and amongst themselves. The stockholder shall be personally liable for corporate torts unless the corporation has obtained reasonably adequate liability insurance. Section 100. When a board meeting is unnecessary or improperly held. Unless the bylaws provided otherwise, any action taken by the directors of a closed corporation without a meeting called properly and with due notice shall nevertheless be deemed valid if: first, before or after such action is taken, a written consent thereto is signed by all the directors. In this situation, there is already a written consent signed by all of the directors. Then, there is an implied ratification and it is considered as a valid corporation action. Second, all the stockholders have actual or implied knowledge of the action and make no prompt objection in writing. In this situation, all of the directors knows that there is a such action, but they did not take an action in writing an objection, then there is an implied ratification and it is considered as a valid corporate action. Third, the directors are accustomed to take informal action with the expressed or implied acquiescences of all stockholders. In this situation, the directors are already used to this kind of setup. Then, it is considered as a valid corporate action. Lastly, all the directors have expressed or implied knowledge of the action in question, and none of them make a prompt objection in writing. In this situation, all of the directors knows that there is such action and question that action, but none of them make a prompt objection in writing. Still, the action is considered as a valid corporate action. An action within the corporate powers taken a meeting held without proper call or notice is deemed ratified by the directors who failed to attend, unless, after having knowledge thereof, the directors promptly files his written objection with the secretary of the corporation. In this situation, still, if one of the directors objected to a certain promptly held meeting, then he can file a written objection with the secretary of the corporation.
Section 2. Preemptive right in closed corporation. The preemptive right of stockholders in closed corporation shall extend to all stock to be issued, including issuance of treasury shares, whether for money, property, or personal services, or in payment of incorporate debts, unless the articles of incorporation provide otherwise. In other words, unless the articles of incorporation state otherwise, the preemptive rights of stockholders in closely held corporation extends to all stock to be issued, including issuance of treasury shares, whether money, property, or in payment of corporate debts. Section 103. Amendment of Articles of Incorporation. Any amendment to the Articles of Incorporation which seeks to delete or remove any provision required by this title to be contained in the Articles of Incorporation, or to reduce a quorum or voting requirement stated in said Articles of Incorporation, shall not be valid or effective unless approved by the affirmative vote of at least 2/3 of the outstanding capital stock, whether with or without voting rights, or of such greater proportion of shares as may be specifically provided in the Articles of Incorporation, for amending, deleting, or removing any of the foresaid provision at a meeting duly called for the purpose, or in other meaning of the Section 103. The Articles of Incorporation shall not be valid or effective unless approved by the affirmative vote of at least 2/3 of the outstanding capital stock, whether with or without voting rights, or of such greater proportion of shares. The question is, can you amend Articles of Incorporation? The answer is depending on the states in which business is incorporated. An anonymous agreement from all the shareholders may be required to change the articles of incorporation. Most states have changed this older common law rule and now only require a majority of shareholders to agree the change of the articles of incorporation. Section 104 Deadlocks. Notwithstanding any contrary provision in the articles of incorporation or bylaws or agreement of stockholders of a closed corporation, if the directors or stockholders are so divided respecting the management of the corporation's business affairs and affairs that the votes required for any corporate action cannot be obtained, with the consequence that the business and affairs of the corporation can no longer be conducted to the advantage of the stockholders generally. The Securities and Exchange Commission, upon writing petition by any stockholder, shall have the power to arbitrate the dispute in the exercise of such power. The Commission shall have authority to make such order as it deems appropriate, including an order, number 1, cancelling or altering any provision contained in the Articles of Incorporation, bylaws, or any stockholders' agreement. Number 2, cancelling, altering, or enjoining any resolution or act the corporation or its board of directors, stockholders, or officers. 3, directing or prohibiting any of the corporation or its board of directors, stockholders, officers, or other persons party to the action. 4, requiring the purchase of at their fair value of shares of any stockholder, either by the corporation, regardless of the availability of unrestricted retained earnings in its books, or by the other stockholders. 5, appointing a provisional director. 6, dissolving the corporation. Or 7, granting such other relief as the circumstances may warrant. This section allows the Securities Exchange Commission, upon a stockholder's written petition, to intervene in order to arbitrate a dispute or deadlock in closed corporation. There is a dispute or deadlock when the directors or stockholders are so divided respecting the management of the corporation that the required votes for any corporate action cannot be obtained, with the consequence that its business can no longer be conducted to the advantage of stockholders generally. Section 105, withdrawal of stockholder or dissolution corporation. In addition, and without prejudice, the other rights and remedies available to a stockholder under this title, any stockholder of a closed corporation may, for any reasons, compel the said corporation to purchase a share at the fair value, which shall not be less than the fair or issued value, when the corporation has sufficient assets in its books to cover its debts and liabilities, exclusive of capital stock, provided that any stockholder of a closed corporation may, by written petition to the Securities and Exchange Commission, compel the dissolution of such corporation whenever on any of acts of the directors, officer, or those in control of the corporation is illegal or fraudulent or dishonest or oppressive or unfairly prejudicial to the corporation or any stockholder, or whenever corporate assets are being misapplied or wasted.
Title 13, Special Corporations. Chapter 1, Educational Corporations. So, what is educational corporations? It is a stock or non-stock corporations organized to provide facilities for teaching and instruction. Section 106, Incorporation. Educational corporations shall be governed by special laws and by the general provision of this code. This means that all educational corporations must be operated in line with the special laws, and also it relates to the general provisions of this code. Section 107, Prerequisites to Incorporation. Except upon favorable recommendation of the Ministry of Education and Culture, the Securities and Exchange Commission shall not accept or approve the articles of incorporation and bylaws of any educational institution. Means that the Securities and Exchange Commission will never agree or approve the articles of incorporation and bylaws of any education if it's not agreed or approved by the Ministry of Education and Culture. Section 108. Board of Trustees. Trustees of educational institutions organized as non-stock corporations shall not be less than 5 nor more than 15, provided, however, that the number of trustees shall be in multiples of 5. The Board of Trustees in the educational corporation is called a non-stock corporation, where it consists of not less than 5 or not greater than 15. The number of trustees should be multiples of 5, like 5, 10, and 15. It will never be 8, 7, or whatever number which are not multiples of 5. When it comes to the interval of changing position, the first elected trustee have 1 year in service, while the followed elected trustee have 5 years in service. Next, Chapter 2. Religious Corporations. So what is religious corporations? It is composed of entirely spiritual persons and which is organized for the furtherance of the religion or for the perpetuating the rights of the church or for the administration of church or religious work on property. Section 109. Classes of religious corporations. Religious corporations may be incorporated by one or more persons. Such corporations may be classified into corporation sole and religious societies. Religious corporations shall be governed by this chapter and by the general provisions on non-stock corporations insofar as they may be applicable. It means that religious corporation can be governed by one or more individuals, and the corporations can be grouped into 2, namely a corporation sole and religious societies. Where corporation sole is consists of one person or one corporator and his successors such as archbishop, bishop, priest, minister, and the such. And religious society it is incorporated by an aggregate of persons. Section 110. Corporation sole. For the purpose of administering and managing, as trustee, the affairs, property, and temporalities of any religious denomination, sect, or church, a corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of such religious denomination, sect, or church. A corporation sole in a religious corporation is managed and carried by a known leader like archbishop, bishop, priest, minister, and the such, which is in line with the church, having the purpose of administering and managing as trustees. Next is Section 111. Articles of Incorporation. In order to become a corporation sole, the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church must file with the Securities and Exchange Commission of the Articles of Incorporation setting forth the following. First is that he is the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of his religious denomination, sect, or church, and that he desires to become a corporation sole. Next is that the rules, regulation, and discipline of his religious denomination, sect, or church are not inconsistent with his becoming a corporation sole and do not forbid it. Third is that as such chief archbishop, bishop, priest, minister, rabbi, or presiding elder, he is charged with the administration of the temporalities and the management of the affairs, state, and properties of his religious denomination, sect, or church within his territorial jurisdiction, describing such territorial jurisdiction. Number 4 is the manner in which any vacancy occurring in the office of chief archbishop, bishop, priest, minister, rabbi, of presiding elder is required to be filled. according to the rules, regulations, or discipline of the religious denomination, sect, or church to which he belongs, and lastly, the place where the principal office of the corporation sole is to be established and located, which place must be within the Philippines. The articles of incorporation may include any other provision not contrary to law for the regulation of the affairs of the corporation. Those mentioned are the following bases of articles of incorporation that are needed to be submitted to the SEC in order to be called as corporation sole.
112. Submission of the Articles of Incorporation. The Articles of Incorporation must be verified before filing by affidavit or affirmation of the Chief Archbishop, Bishop, Priest, Minister, Rabbi, or Presiding Elder, as the case may be, and accompanied by a copy of the acclamation, certificate of election, or letter of appointment of such Chief Archbishop, Bishop, Priest, Minister, Rabbi, or Presiding Elder, duly certified to be correct by any notary public. 112 is in relation to the RCC in the section 109. There are articles that necessary to comply to become a corporation sole. Section 112 means that before filing the article of incorporation, the appointed leader is required to have the affidavit or affirmation of the chief archbishop, bishop, and etc. as the proof that you have been appointed as the corporation sole. After gathering all the essential documents, it will be submitted to the Securities and Exchange Commission for the sole corporation's sake. Take note. From and after filing, religious denomination was already incorporated as a corporation sole. And also take note that religious denomination does not require approval by the SEC of the Articles of Incorporation. Next, Section 113, Acquisition and Alienation of Property. This certain section means that as a corporation sole who hold a property, the bishop, archbishop, and etc., he have the right to sell the property. But before the bishop, archbishop, and etc. sell the property or mortgage real estate, he needs first the issuance from the regional trial court to have proof that the bishop, archbishop, and many more may able to sell the properties. And in case if there is a member of the religious denomination tried to interfere or hamper the bishop, archbishop, and etc. who lead the corporation to sell the properties, there is provided response to that certain case. If there is written regulation in the religious denomination about acquiring, holding, selling, and mortgaging real estate, which is implemented by the corporation sole, in the end, that bishop, archbishop, and etc. ay siya pa rin ang mananaig or prevail than others, even intervention of regional trial court is still ineffective. Section 114, Filling of Vacancies. This section means that if there are vacancy, there is followed a successor. The successor will become a corporation sole after the successor submit notarized documents as an evidence and use as a proof that he, a successor, can take over the position. But if there is no successor yet, the authorized or empowered persons may have the power to lead the corporation as well as administering and managing all the properties for the benefits of religious denomination, church, and Section 115, Dissolution. This section means that the corporation sole will not be dissolved unless the bishop, archbishop, and etc. that being appointed as corporation sole to administer and manage the properties of the religious denomination itself will file for the verified declaration of dissolution. And the contents of dissolutions are the following. First, the name of the corporation. Second, the reason for dissolution and winding up. Third, the authorization for dissolution of the corporation by the particular religious denomination, sect, or church. Fourth, the names and addresses of the persons who are to supervise the winding up of the affairs of the corporation. Section 116, Religious Societies. Religious societies defined under the RCC Section 107. It is incorporated by an aggregate of persons. This certain section means that informing religious societies should undergo process which could lead to votings from administered person for approval of making such groups, and also together with approval of Securities and Exchange Commission. Matters to be set forth. Number 1, the religious society or religious order or diocese, synod, or district organization is a religious organization of a religious denomination, sect, or church. Number 2, at least 2/3 of its membership have given their written consent. Number 3, that the incorporation of the religious society or religious order or diocese, synod, or district organization desiring to incorporate is not forbidden by competent authority or by the constitution, rules, regulation, or discipline of the religious denomination, sect, or church of which it forms a part. 4, that the religious society or religious order or diocese, synod, or district organization desires to incorporate for the administration of its affairs, properties, and state. Number 5, the place where the principal office of the corporation is to be established and located, which place must be within the Philippines. Lastly, the names, nationalities, residences of the trustees elected by the religious society or religious order or the diocese, synod, or district organization to serve for the first year or such other period as may be prescribed by the laws of the religious society or religious order or of the diocese, synod, or district organization, the board of trustees to be not less than 5 nor more than 15.